Hey everybody, welcome back to my slightly less messy office. The bathroom's almost done. Tonight we are talking with my friend Curt, who is a patent and IP attorney. We actually recorded a conversation a long time ago, but there was some technical problems and we couldn't get the videos to mesh together. So thankfully, Curt was willing to come on again and have another conversation about his job. It's a good one. It's interesting. I learned a lot about patents and copyright and trademarks. I hope you learn a lot too. And don't forget to share this video with your career curious friends. Who are you and what do you do?
My name is Curt Lockhart, and I am a patent attorney, patent and intellectual property.
When I was in engineering school, everybody always said the the manufacturing engineer technology people out of all of the engineering majors made the least, and the chemical engineering people made the most. And then anybody from those who went and became a patent attorney made way more than everybody else. And I think you did chemical engineering, right?
I did do chemical engineering, yeah, into
So does that mean you're just rolling it in?
no, actually, so, well, I mean, patent attorneys do they do all right. So it depends on the context, right? So, but on average, I would say patent attorneys are probably uh, better paid than other attorneys in other areas, but it really just depends on the context, what you do, who you work for, that sort of thing. So, but I honestly like chemical engineering plus patent attorney is not necessarily the optimal combination, especially for earning potential. You're probably better off with probably electrical engineering is well, it's definitely the most sought after in the field, and so you're going to have your pick at jobs and and lots of opportunities in the field if you have an electrical engineering degree and then go into patent law. Probably closely followed by computer engineering or something in that field. Chemical engineering, not necessarily. I guess it doesn't necessarily translate from an earning potential as well into patent law as
But
you
it's
would do it
still a
if you're an
good
engineer. So
it's still a good technical foundation for patent law or IP law.
yeah, for sure. I mean, any engineering degree, you're not gonna like if you're gonna do patent law. Like I was talking recently to a girl that's still an undergrad that's considering patent law, and she was kind of trying to figure out what was the best undergrad and things like that. And so we were talking through it. I think she was studying like biochemistry or something like that. Um, but yeah, any engineering discipline is probably going to be give you kind of a leg up in if you're going into patent law versus maybe some of these other science fields. But really, any science or engineering degree is going to qualify you to practice patent law to some degree. So some fields are kind of notorious for requiring like a higher level of education. So like if you're an engineering degree, you're fine with a bachelor's, whereas if you're something like biochemistry or biology or something like that, you might need a master's or PhD level
Yeah.
degree to kind of get your foot in the door for patent law.
So is law school different for a patent attorney? Or is it the same kind of 3 years and maybe you just pick some classes for patent law?
Yeah, I mean it can be. I mean it's still the same 3 years, so you got to and you still have to take the foundational classes like everybody else. So you still have to pass the bar just like any other attorney. The main differences, well, number one would be in order to practice as a patent attorney, where you represent inventors filing patent applications with the United States Patent and Trademark Office, you have to pass what's unofficially known as the patent bar. So it's like an additional exam
Okay.
that you have to sit for and pass to qualify as to be an actual practicing patent attorney. But other than that requirement, really it just comes down to if you may take some electives specifically related to patent or IP law if they're available. Not honestly, not a lot of law schools even necessarily have courses like that. And so for me,
Mhm.
like personally, I picked a school that was known for IP, patent law in particular, and specialized in it. So it had a lot of those types of courses available. But if you're just going to any, random law school or the top law school that you can get into, the chances of them specifically having courses in that field are not necessarily high. And so
Yeah.
you would take, whatever they've got available. I mean, I would say probably law schools at least have some degree of some class available, but it's you're not going to have nearly the type of selection as if you went to a school that specifically focuses on that discipline.
Okay. Did you know that you wanted to be a patent attorney like before college? Was that always your plan?
Not really, not before college at least. It was always kind of on the back of my mind. I mean, I knew some patent attorneys growing up, some family friends and things like that. And so I kind of knew a little bit, I at least kind of knew about the field. Um, but it wasn't necessarily a plan of mine or on my radar. It probably wasn't until I was like a junior in college that I really committed to doing that.
Okay.
Just after deciding, that a full career in that field wasn't really the path I wanted to pursue. But I did intentionally pick engineering, knowing that it would be could potentially be a stepping stone in
Yeah.
that direction.
Okay. So then what's after that? You decide that you are thinking patent law sounds good. You're in your junior year. Does that change your course load for your last year of college, or you just kind of finish up your degree, take the LSAT, and hope you get in? How does that timeline look?
Yeah, for me, I didn't change a whole lot, at least not as a requirement for going to law school. I mean, that's one of the nice things about law school is there aren't necessarily prereqs like they are for medical school, for example. Like I actually
Yeah.
at one point thought maybe medical school, and so I took some of those prereqs that I would need for medical school. So it was originally like a chemical engineering kind of into pre med. I only took a handful of courses, but law school doesn't really have the same prereqs or anything. So you can really take anything and still take the LSAT and get into law school just fine. I did end up minoring in computer science, but it wasn't anything related to law school or going into patent law. It was just I took an elective doing programming and really liked it, and so
Yeah.
I wanted to take more courses and it was just something that I wanted to learn more about and kind of get that skill set. But yeah, not it wasn't specifically required for law school.
I This is a little unrelated, but I kind of wish I had taken an intro to computer science or intro to coding class. The development class that they had for mechanical engineers was just, I mean, it's different now. I have a friend who's a professor there now, so I know it's different, but the class that we had to take was like straight into pretty low level coding in C++, plus plus,
Hmm.
and it just went straight over my head. I had no idea what was going on. And now I write code in Python like every day.
There you go.
That's my job.
Yeah.
And so I kind of wish I had had a better beginner kind of introduction to it. And I think I may have also like done a minor because it's a really useful skill to have.
Yeah.
It was a useful skill back then and it still is now.
Still
Anyway,
relevant. Yeah.
that's great that you figured that out. I never did.
Yeah, yeah. I had a brother that was very sharp in that field, and he kind of was a little, he was kind of pushed me in that direction. It was a good resource, so I had at least a little bit of help in that regard.
Yeah. Okay, so you graduate, you got a chemical engineering degree, you go off to law school, 3 years, you take the bar, you take the patent bar, and then where does your career go from there?
Yeah. So after law school, I started at a law firm specifically focused on patent work, so patent prosecution. So I was writing patent applications, and it's kind of where I got my start. Then I moved over to another firm that was focused more on trademark related work. So I did a fair bit of trademark work there, some litigation as well. So it's kind of where I got my foundation. I'm a little bit unique in the sense that I have a pretty good handle on both patent and trademark law, which is fairly unique. Usually, patent attorneys are very specifically focused in patents, and same thing on the trademark side. There doesn't tend to be a lot of overlap there in terms of attorneys that do both. So got a little bit of a unique skill set by learning those two different disciplines, and then after that is when I went off and started my own firm full time, and so now I'm a solo attorney. So I practice both patent law and trademark law, but pretty heavily involved on the patent side, especially as it relates to representing inventors before the patent office. So and that's where I am now.
So give me the 2 minute explanation. What is the difference between a patent and a trademark and a copyright? And what does the little R in a circle mean? And what does the little C in a circle mean? And
Yeah.
just give us the really easy, high level kind of difference there.
Sure. So patents generally are focused on inventions. So if you invent something new, so typically a physical product, but in today's world, not necessarily. So it could be software related or AI or whatever. So, but typically it's something new that's never been done before. So if
Okay.
you've created something new, you can usually that's going to fall in the realms of a patent. Trademarks are specifically focused on your branding. So it's related to your brand and your brand image and your marketing. It's the asset that is supported by your brand, right? So it's the legal rights tied to your ability to identify and distinguish your products and services in the marketplace, and distinguish them from somebody else's, right? That may offer similar products and services. And so trademark is how customers can identify that it comes from you and not from somebody else. And then copyrights are specifically for creative works. And so it's creative expression. And so a general idea isn't necessarily protectable from either a patent or a copyright. But when you turn that idea into specific expression, so copyright you can think of more from a creative side of things versus patents are tend to be more technical, inventions and things like that. So copyrights, if you're an artist, right, you paint or you draw, or you're a musician, you're an author, you write books, those are all creative works, right? So writing a book isn't new, it's not novel, so you're not going to get a patent for your book, but your specific book and your creative expression in writing that book is what qualifies for copyright protection. So
So the novel is not novel.
exactly. So
Ha ha.
and
Put
then
in.
to answer your question about the symbols, so the C with the circle around it is just a copyright symbol, so you can stick it on a work that just indicates it's a public notice that this is a copyrighted protected work. Then the R with the circle around it means registered trademark. And so the other symbol that you may have seen around is a little TM. You might see that next
Mhm.
to some logos and brand names and things like that. So the difference between the R with the circle around it and the little TM is TM just means it's any trademark unregistered. Anybody can use it without even having the trademark registered. It just is a indication that brand or business treats it as a trademark. And then once you get it registered officially, you can change that to an R with a circle around it. So it's just an indication that now that's
Oh,
a registered trademark. So
I
they're
didn't know
treated a
that.
little bit differently, for legal purposes. And so it's just the distinction between the two.
I feel like I got to use that on on our next trivia night. What's the difference between the R and the TM? Because I didn't know until just now. That's
There you go.
interesting.
Yeah.
So, um, okay, the I've got a couple other questions swimming around in my head.
Sure.
First that I think I'm going to ask is if there is some new invention or some improvement on some existing thing. Um, I read somewhere, in fact, I think it was a book that you recommended, that copy or patents don't provide protection, but rather they provide, I think it said like offensive rights. So if you have a patent for something, that doesn't mean you're protected from anyone stealing your idea. It just means you have a legal right and documentation to sue somebody if they copy your idea. Is that right?
Yeah, more or less. I think I understand kind of what you're getting at. Another thing, yeah, I mean, a patent in and of itself is like the patent office is not going to be the police for your patent. Like that falls on the patent owner, and so they're responsible for deciding what is and isn't patentable. But once they decide that your invention is patentable and they give you your patent, now it's up to you to do something about it and enforce it, right? You
Okay.
Anybody is free to do what they want until they are told otherwise, right? And so if somebody goes out there and they're infringing on your patent, it's up to you as the patent owner to do something about it and have them stop. Nobody else is going to enforce it for you. And so you have to actually proactively, notify them of your patent rights. It typically, that's the first step. And then if it can't be resolved from there, you would go a step further and you may end up in court having sued them for patent infringement. But that's the method for resolving these types of disputes. And so I think more or less that kind of gets at what you were trying to get at.
Yeah.
The other thing, though, that's kind of interesting that I don't think a lot of people realize for patent purposes too is that having a patent on your invention is actually not like a stamp of approval that you're good to go. It's not an approval of like you you are good to go here. You're not infringing on anybody else's rights. It's really only an exclusive, like it's a right to exclude, not like permission to do something. So in theory, I could get a patent on something that is like my invention could in theory infringe on somebody else's patent. And so I could still get a patent for it, but if I practice my invention, I could be infringing on somebody else's patent. And so I need to be aware of that. It's not like, hey, a stamp, you're good to go. There could be overlap that prevents you even from making your own invention, even if you have a patent on it. So what it really does is it allows you specifically to exclude anybody else from practicing your invention, but it doesn't give you permission to necessarily practice it yourself, if that makes sense.
That's
It's kind of
interesting.
complicated, but
So if that's the case, then why get a patent at all?
well, I mean,
That's, I mean,
yeah,
broad
I mean,
question here,
it's a
but
good question. But just having I mean, just having the right to exclude others from practicing your specific invention, and so, I guess, I mean, I can try to illustrate it with an example. One I tend to use that's kind of easy and straightforward is just a basic like invention for a chair, right? And so let's say I invent a chair. It's got, legs, a seat, and a back, and it's just a basic chair, right? I patent that, and so it requires the elements of, four legs. It's got a seat and it's got a back, and that's my invention that I've claimed in my patent application. You might come along and say, well, that chair would be way cooler and more useful if I put wheels on it so I can roll it around at my desk. Right now, I turned it into an office chair. It's way better, right? It's a better chair. So by virtue of putting wheels on it, you have turned my invention into a better invention, and it's a new invention because nobody else had thought to put wheels on it. So you thought of that, and it was new and better. So you get a patent for your seat, four legs, a back, and now you've got wheels on the legs, right? And so the patent office gives you a patent for that new and improved chair. The problem is every element of your invention is already covered by my patent. And so you, by virtue of making your chair, are infringing on my patent. And so, but it doesn't necessarily mean that getting your own patent isn't useful, because you have invented something that's new and better. And so in a situation like that, what may end up happening is you may come to me and say, hey, look, Curt, I know you've got a patent for that chair. I've got a better chair. Let's work together. You give me a license to practice, to build my invention that's better. I'll give you a license, and we'll just work together, and we can both, mutually beneficial for us both, right? It's what's known as so my patent's known as a blocking patent for you, because it blocks you from being able to create your
Mm-hmm.
invention. But if we license it to each other, that's known as a cross license, right? And so we both benefit, because I say you can make your chair that's better. I'll give you a license to practice your invention, and then you license yours back to me, and we all win, right? Because you came up with something better that improved on my original invention, right? And
Yeah.
so, in that sense, having a patent is still better than not having a patent. But that kind of illustrates the example of how you may run into a situation where you're not necessarily good to go just because you got a patent. But there are almost always ways to work through situations like that. It's not very common, but it's just kind of an easy example to illustrate the point
Yeah.
that you're not necessarily, like, it's not a stamp of approval that you're good to go. There's a lot of other factors that go into it.
Okay. Um, so one more question, then we'll get back to talking more specifically about your job, your career. Um, I've told you before about this new startup that my friend is doing that I've kind of been helping with and hoping to get more involved with.
Yeah.
At first, we were really thinking, okay, this is a new invention. We need to get a patent. We at least need to put in a provisional application as soon as possible so that we've got first file rights. And then we realized after a while that working on the patent felt like it was distracting from actually developing a good working product. In general, do you feel like it is really important to get a patent application or a provisional patent application in early? Or does it sometimes make sense to just skip the patent altogether and hope you make a good product that people want to buy, even if technically someone might be able to copy your idea?
Yeah, it's a good question. There's definitely a balance, and there's just there there are lots of factors to consider. But ultimately, at the end of the day, the most important thing is a good product that people want, right? Because that in and of itself is what has value. And so a patent is just a way to leverage that into higher, more value, right? Or more
Yeah.
enterprise value, because now you have control over the supply of that product that everybody wants to the market, right? Without the control over the supply, it might become a less, like, you increase competition, right? It might drive down prices, things like that. And so there are other market forces at play. But ultimately, at the end of the day, the product and its, utility and value to the marketplace is what is king here, right? Like a
Okay.
patent, you can get, you know, you could have a really, unusual product that's new and different, and it could be patentable. But if nobody wants it, then it's just a patent. It just sits on the shelf, right? And so,
Right.
like the patent is only as valuable as the product itself. And so always, you want to focus on having a product that the market likes, and that's, you know better and useful, and has value in the marketplace. And then you can, talk about how patents might play into that, as far as leveraging that, to increase the
Okay.
value, sort of thing. So,
That makes sense. So let's we'll kind of switch back to your career. Went down the rabbit hole about patents and all of that different stuff, which is really interesting to learn about.
yeah.
Um, the one thing that I've been thinking about is, do you feel like your job is relatively stable and secure? And another way to think about it, like maybe a tangential question, is, do you feel like AI is going to get pretty good at your job? So answer both of those.
Yeah,
I'm
no,
interested in.
interesting questions for sure. I honestly, I don't know the answer to the question about AI. I'm not, like, AI is a great tool, fantastic tool, and in a lot of ways, I think it helps. in a lot of fields um, just improve efficiency and just like I think if it's leveraged can certainly be a help for in a lot of different fields, mine included, right? And so I use it heavily in my work just for a variety of things, for writing better, for research purposes. I use it a lot, right? Because I just by nature of what I do, I have to kind of know a little bit about a lot of different things. I
Mhm.
obviously rely heavily on the inventors for their expertise, but I typically take what they give me and having a high level understanding of it can leverage AI to help me understand better, right? The
Yeah.
concepts that we're talking about. And so then I can um, translate that into language that works for patent purposes and things like that. So certainly AI. I don't know, to answer your question though, whether or not it will become so good that it essentially makes my job obsolete. I couldn't tell you for sure, but I think to a certain degree there's just human judgment and human just individual knowledge and expertise in fields. I want to hope and say that it will just make that make us more efficient and productive in what we do, but we're still needed in terms of our expertise in these particular fields. So,
Yeah.
but beyond that, as far as like job relevancy and stability, I would say like patent law is generally known to be um, fairly stable, at least within my the field of legal practice. I remember before I went to law school, like I would tell people, "Oh, I'm thinking about going to law school." I'm like, "Oh, like people that had been to law school and were lawyers." I'm like, "Oh, don't do that. You don't want to
Yeah.
do that, right?" And then they're like, "Wait, like what type of law are you thinking of practicing?" I'm like, "Oh, I want to be a patent attorney." Like, "Oh, okay, yeah, that's a good field, right?" So it's like it's always been known as one of the better fields for practicing law, just because of how specialized it is. Just this combination of like engineering and law, it's really not that common, and so you get less than 1%, I think, maybe 0.5% of all practicing attorneys are patent attorneys, right? And so it's a very kind of specialized area of the law specifically, but um, even beyond that, like I think just the way the world works and like society, people are always innovating, right? That's just in human nature, right? Is to come up with
Right.
new and better ways of doing something. Like that's our purpose as humans is to build things and work and discover and things like that. And so like inherently it just fuels that the innovation and technology advancement is just always fueling the need for patent and intellectual property support on the back end.
Yeah.
So
That makes sense.
for that reason, yeah, I mean, I've never been overly concerned with you know
Are you going to
having
have
work to
jobs?
do or
Yeah.
AI necessarily taking over for the job. Although in a lot of ways it is really advancing well. But I mean, I leverage it just as much as anybody else in my work. So
Yeah. Um, Here's something I thought of. You, I think you called it you prosecuting a patent. Is
mhm.
that right?
Yeah,
That means you're submitting the patent application and going back and forth with the patent office to get a patent. What's the word? To get somebody the patent, right?
yeah, kind of a patent issued or granted.
Issued. That's what I was thinking of. Have you ever, or is this part of your job, that if somebody infringes on a patent, do they call you to sue the people who are infringing, or is that a different lawyer that they would want to talk to?
Yeah, it comes up. I mean, like naturally, it comes up because like if I work with an inventor and we get a patent, then usually I'm kind of we have a relationship or they know me, and so they'll kind of come to me if there's infringement and going on. So usually, like to a degree, I can be involved in that to an extent, but it's fairly unusual for like in the realm of patent attorneys, you're either what they call litigator or a patent prosecution. It's kind of a weird prosecution is a little weird term. I don't know why they call it that, but like it kind of sounds weird because you think of a prosecutor as like criminal, criminal
Yeah.
prosecution. It's that's what it's called, but it's not related. So patent prosecution just means you're working with inventors at filing patent applications and prosecuting with the patent office, and so getting an actual patent granted. Litigators are the ones that go to court and actually fight, sue people for infringement and fight over patent rights and things like that. And so it's pretty unusual that you would have significant overlap there. Typically, patent attorneys are either a litigator or a prosecutor, usually not both. And so I personally don't do a lot of litigation. And so um, if there are disputes related to patents, sometimes I'll help in the early stages to maybe resolve something if it maybe just needs a license agreement or something to settle the dispute early. I might be involved in that process a little bit, but at a certain point, especially if we're actually filing lawsuits and things like that, at a certain point I would pass that off to somebody that's dedicated to litigation.
That makes sense.
So, yeah,
But
it's
they're
just a different skill set, different. Yeah, it's just from an attorney's perspective, they're not really related, and so
and
a good litigator is not necessarily a good prosecutor, and vice versa.
but they're both patent attorneys. There are patent specific litigators, and of course the patent prosecutors,
Yes,
right?
yes. Although, so if you're doing patent prosecution, you would be required to have passed the patent bar, like we talked about earlier.
Yeah.
For litigation, not necessarily. And so I've known of
Okay.
attorneys that weren't patent attorneys necessarily; they were just regular attorneys that did patent litigation specifically. So
I see.
so
Okay.
you can get into patent litigation, without actually being a patent attorney. Although certainly having passed the patent bar, there's at least a good number of patent litigators that are still qualified patent attorneys.
Yeah.
But there's not necessarily that same requirement. If you're on the prosecution side, however, you would have to be qualified as a patent attorney specifically to do that.
Makes sense. Is there anything else that we should have talked about your career? Any advice for people thinking about this? Do you want to try and scare them away from law school? And anything else you want to leave us with?
Um, no, I wouldn't scare anybody away from patent law. I mean, I like it. I like what I do, but granted, it's not for everybody. It's there are plenty of people that probably wouldn't enjoy what I do, but a lot of reading and writing, and it can be pretty technical. And so, like, if you've ever read a patent application, which I'm sure you have in your work that you're doing, they can be pretty dense. And so
Yeah.
yeah, so but again, I mean, again, that's where AI comes in, right? You leverage AI to like distill concepts down and be like, take this passage and explain it to me in terms I can understand, sort of thing. And so in that regard, I mean, honestly, AI has been great. I'm fortunate to have for it to be available kind of early in my career, because I imagine the job would have been substantially different before that was widely available. So, but no, I don't know that I would necessarily discourage anybody from. It's a good field as long as you like that kind of work. I mean, I think the thing I like most about what I do is I just get to work with a lot of inventors and people that are kind of thinking of new ideas. Not, I mean, not every idea that comes across my desk is like revolutionary and amazing, like going to change the world type amazing. The vast majority of inventions and patents are just incremental improvements on things, especially nowadays. I mean, the way technology is advanced, it's just very difficult to come up with something that's completely um, out of left field. And so
Yeah.
the vast majority of innovation is just kind of building blocks, one on top of the other, sort of thing. And so, but it's nice to be in that space where you're just kind of seeing the things that people are working on, and just working with closely with inventors that get very excited about their idea and things like that. That's just, for me is rewarding. So, but other than that, no, I like what I do. I'm not. I would encourage anybody that is interested to kind of pursue it and see if it's a good fit for them.
That's it. Thanks for watching. Thanks to Curt for coming on again to tell us all about his job as a patent attorney. This is an interesting one for this time around because I actually have with my friend a patentable idea that we are going to spend some time developing to try and get a new business started up. And because of that, I need to start spending the time that I have been spending recording and putting together these videos on developing this new product, this new technology. So for now, this is probably going to be the last video on the channel. Depending on where this other project goes, I may or may not be back. When I do come back, I've got some ideas to make this channel a little bit better. So if that happens, stick around and you'll get to see it firsthand. But for now, I really appreciate everybody who's been here to follow along. Please still share these videos with anybody who you think might find them useful. And if it continues growing, then I'll be right back to make more videos. Thanks again.